On behalf of the judicial officers of the 7th Judicial District, welcome to the Domestic Relations Case Orientation and thank you for being here today. This orientation is required for all parties in domestic relations cases who are not represented by an attorney and is meant to help guide you through your case. Today, we are going to share with you important information about how your dissolution of marriage, dissolution of civil union, legal separation, invalidity of marriage, or allocation of parental responsibilities case will proceed. This video will share general information about your case. After you watch the orientation video, your cases will be individually handled by the Family Court Facilitator, who will set specific deadlines for the documents that need to be filed in your case and answer any questions you may have. The Family Court Facilitator may also help you reach temporary agreements in your case, schedule your case for mediation, or refer your case to a magistrate or judge for further hearings. Please take out the initial Domestic Relations Case Management Order, which scheduled your initial conference for today. This packet will say Initial Domestic Relations Case Management Order in the caption and will have today's date and the time of your initial conference on the first page. The initial Domestic Relations Case Management Order will serve as your guide throughout this video. If you need a copy of the initial Domestic Relations Case Management Order, please raise your hand now. Please direct your attention to paragraph 5 on page 1 of the Case Management Order. Paragraph 5 states that if you choose to represent yourself in your case, you are required to follow the same procedures as a party with an attorney. For example, you must comply with all Colorado laws, local procedures, and court orders, and if you do not comply with such laws, procedures, and orders, the consequences will not be relaxed because you are representing yourself. The procedures that must be followed in a domestic relations case are primarily found in Rule 16.2 of the Colorado Rules of Civil Procedure, which are available on the Colorado Judicial Branch website or in print at the Self-Help Center, as outlined in paragraph 9 of the Case Management Order. If you have general procedural questions, you can contact the Self-Represented Litigant Coordinator, Leslie German, at 970-252-4312 to schedule an appointment. The Self-Represented Litigant Coordinator can help answer procedural questions, but she cannot give you legal advice. If you feel that you need legal representation, you may choose to hire an attorney at any point in your case. We will now go over some of the important procedures that must be followed in your case. You must keep an updated mailing address on record with the court. If you change your mailing address, you must file a Notice of Change of Address form with the court clerk's office and provide a copy to all other parties in your case. The court will not update your mailing address and will continue to send mail to the address of record in your court file unless you file a written request to change your address in this case with the court clerk's office. All documents that you file with the court must contain a caption that includes the court location of your case, the names of the parties to your case number, and the title of the form you are completing. Do not file handwritten letters or exhibits such as photographs with the court unless the letters or exhibits are attached to a court form that includes a caption. Every time that you file a document with the court that is not signed by all parties in your case, you must provide a copy of that document to all other parties in your case by mail, fax, or hand delivery. You must also sign and file a certificate of service for every document that you file with the court that is not signed by all parties in your case to show the court that a copy of the document was sent to all other parties in your case at the address of record on file with the court for every party. If another party in your case is represented by an attorney, you must provide copies of all documents that you file with the court directly to that party's attorney, not to the other party, and list the party's attorney as the individual to whom you sent a copy of the document you filed with the court on the certificate of service. We will now go over the documents that must be filed in your case. The forms that we discuss are available for purchase at the court clerk's office, the large glass window on the first floor of the courthouse, or for free on the Colorado Judicial Branch website under the Self-Help/Forms tab. As outlined in paragraph 5 of the case management order, if you need assistance filling out forms, you can contact the self-represented litigant coordinator, Leslie German, at 970-252-4312 to schedule an appointment. The self-represented litigant coordinator can help you fill out forms and answer procedural questions, but she cannot give you legal advice. Additional information about the procedures you must follow throughout your case are included on pages 2 and 3 of the case management order under Case Procedures for Domestic Relations Cases. Please turn to paragraph 17 on page 3 of the case management order. If you did not file your case on your own or as a co-petitioner with the other party, you are the respondent in your case. Paragraph 17 discusses the response. As the respondent in your case, you must file a response to the petition within 21 days of the date you were served with the petition or signed a waiver and acceptance of service in Colorado, or within 35 days of the date you were served with the petition or signed a waiver and acceptance of service outside of the state of Colorado. In order to file the response, you must also pay a filing fee of $116. If you cannot afford the filing fee, you must file a motion to file without payment of filing fees, along with 3 months of bank account statements and 3 months of pay stubs, or an affidavit explaining why you do not have those documents at the time you file your response. The response form is available for purchase from the court clerk's office or on the Colorado Judicial Branch website. The response form is an opportunity to tell the court whether you would like the relief requested in the petition granted, correct any information that was incorrect in the petition, and provide information to the court about the orders you would like entered in your case. Please turn to page 5 of the case management order, which says Attachment A, Mandatory Disclosure. The mandatory disclosures are a list of financial documents you are required by Colorado law to file with the court and exchange with the other parties in your case. The first document on that list, marked A, is a sworn financial statement, which includes a sworn financial statement and supporting schedules. Each party in your case must file these documents with the court and provide a copy of these documents to all other parties in your case. The Family Court Facilitator will set a deadline for filing your sworn financial statement and supporting schedules at your initial conference after this orientation. Documents B through O on this list are financial documents that need to be exchanged between you and the other parties in your case. You need to provide copies of all of the documents B through O that you have in your possession to the other parties in your case, but you do not need to file documents B through O with the court at this time. In order to demonstrate that you have provided copies of all of the financial documents included in Attachment A, Mandatory Disclosure, to the other party or parties in your case, you will need to file a certificate of compliance with mandatory financial disclosures with the court. The certificate of compliance form also allows you to explain why you have not provided some or all of the documents on the list of mandatory disclosures to the other party if you are unable to do so. The Family Court Facilitator will set a deadline for filing your certificate of compliance with mandatory financial disclosures with the court at your initial conference after this orientation. Please turn to page 6 of the case management order, which says Attachment B at the top. Attachment B is an order for parenting education workshop. If your case involves a child or children under the age of 18, you and the other parties in your case are required by Colorado law to complete a parenting education workshop. You may take the parenting education workshop in person or online with one of the approved providers in the 7th Judicial District who are included in this order. If you paid the filing fees to file a petition, co-petition, or response in your case, the cost of the workshop is the first cost listed for each provider on this order. If your filing fees were waived by court order, the cost to take the parenting education workshop is the second cost listed for each provider on this order. If your filing fees were waived by court order and you take the parenting education workshop in person, you will need to present a copy of the order waiving your filing fees to the in-person provider in order to receive the reduced rate for the parenting education workshop. If your filing fees were waived by court order and you wish to take the parenting education workshop for free online, you must fax an application form and a copy of the court order waiving your filing fees to the online parenting education workshop provider. The Family Court Facilitator will provide you with instructions to take the class online for free if your filing fees were waived at your initial conference. In order to finalize your case, there are particular issues that need to be resolved by agreement of all parties in your case or by a judicial officer, a magistrate, or a judge at a court hearing. We will now discuss the forms that address these issues. If you are married or entered into a civil union, the court has authority to make decisions about the division of assets and debts of your marriage or civil union and maintenance, also called alimony or spousal support. In order to finalize your case, you and the other party in your case must file a separation agreement, or a judicial officer will set apart to each party his or her separate property, divide marital property, and determine maintenance at a contested hearing. If you reach a full agreement about the division of assets and debts and maintenance, you need to file one single separation agreement signed by both parties to your case to show the court that you have reached a complete agreement. Your separation agreement must divide all assets and debts that are listed on both parties' sworn financial statements, even if you and the other party agree that the property is separate property or the property has been divided between the two of you. For example, if the petitioner and the co-petitioner or respondent in a case purchase two cars together, and each party lists the car in their own possession on their own sworn financial statement, because the parties agree they will each keep one car, the parties must still list both of these cars on their separation agreement and show the court who is keeping each car and by when the parties will transfer title of these cars if appropriate. In addition, if you have entered into a marriage or civil union, you must address maintenance, often called alimony or spousal support, in your separation agreement. Section 4 of the separation agreement addresses maintenance. According to Colorado Revised Statutes, Section 1410.114, for marriages of more than 3 years in length, there are advisory guidelines for the amount and term of maintenance. You must indicate that you have reviewed the maintenance guidelines in Section 4 of the separation agreement. You can download the maintenance calculator to calculate maintenance in your case on the Colorado Judicial Branch website by going to www.courts.state.co.us and clicking on the Self-Help/Forms tab. Then click All Court Forms and Instructions. Click Divorce, Family Matters, Civil Unions, and then click on Calculate Child Support/Maintenance under the Custody and Child Support heading. The maintenance guidelines are available in print at the Self-Help Center. If it is necessary in your case, the Family Court Facilitator will set a deadline for you to file a separation agreement at the initial conference after this orientation. If there are no minor children of your marriage or civil union, and you come to a complete agreement about the division of all assets and debts of your marriage or civil union and maintenance, you may finalize your case without any further hearings. In order to finalize your case, both parties to your case will need to sign one single affidavit for decree without appearance of parties, and file the affidavit for decree without appearance of parties along with your separation agreement with the court clerk's office. If it is necessary in your case, the Family Court Facilitator will set a deadline for you to file an affidavit for decree without appearance of parties at your initial conference after this orientation. If you were married or entered into a civil union and have at least one minor child with the other party in your case, or were not married but your case involves at least one minor child, the court also has the authority to make decisions about the allocation of parental responsibilities in your case. In Colorado courts, we no longer use the term custody. The court has the ability to make decisions about the allocation of parental responsibilities, which includes decision-making responsibilities, who will make decisions about the child's school, healthcare, extracurricular, and religious activities, and parenting time. In order to finalize a case that involves at least one minor child, you and the other parties to your case must complete a parenting plan which addresses decision-making responsibilities, a parenting time schedule, and expenses related to any child listed on the petition in your case. Or a judicial officer will determine parenting time and decision-making responsibilities at a contested hearing. If you reach a full agreement about all parenting issues, you need to file one single parenting plan signed by all parties to your case to show the court that you have reached a complete agreement. Your parenting plan must also address child support. The child support calculation is based on Colorado Revised Statutes Section 1410-115, which calculates child support based on the gross incomes of the parties, the number of overnights each party has with the child, and the expenses such as work-related childcare, health insurance premiums, and extraordinary medical expenses each party pays for the child. You can download the child support worksheet to calculate child support in your case on the Colorado Judicial Branch website by going to www.courts.state.co.us and clicking on the Self-Help/Forms tab. Then click All Court Forms and Instructions, then Divorce, Family Matters, Civil Unions, and then click on Calculate Child Support/Maintenance under the Custody and Child Support heading. The child support guidelines are also available in print at the Self-Help Center. If you choose to deviate from the child support guidelines that are calculated by the child support worksheet, you must explain why there is a compelling reason to deviate from the child support guidelines in Section D of your parenting plan. If it is necessary in your case, the Family Court Facilitator will set a deadline for filing a parenting plan at the initial conference after this orientation. Even if you can only reach a partial agreement with the other parties to your case, you should complete the forms we just discussed to the extent you are in agreement, sign the forms with all other parties to your case, and file the partial agreements with the court clerk's office by the deadlines set by the Family Court Facilitator at your initial conference. You can indicate on the first page of the separation agreement and parenting plan that the agreements you reached are only partial agreements. If you and the other parties in your case file a partial agreement with the court clerk's office, you are notifying the court that you have only resolved some of the issues in your case. If you only reach partial agreements in your case will be scheduled for a hearing with the judicial officer to resolve the remaining issues. If you and the other party or parties to your case cannot reach full agreements on your own, you may choose to participate in mediation. Mediation is a process during which the parties to a case meet with a neutral third party to try to resolve their disputes by agreement. Generally, parties are more satisfied with solutions reached during mediation because mediation allows the parties to create compromise solutions to parenting or property issues rather than having a judicial officer decide those issues for you at a contested hearing. You may use a trusted friend or family member, a private mediator, or a mediator through the Office of Dispute Resolution to help mediate your case. All parties in your case must agree to participate in the mediation and agree on a mediator. The Office of Dispute Resolution has a contract attorney mediator who provides mediation services at the courthouse each week. The fees for mediation with the Office of Dispute Resolution attorney mediator can range from $10 to $60 per hour per person in a domestic relations case. If you choose to mediate through the Office of Dispute Resolution, mediation can be scheduled through the Family Court Facilitator at your initial conference. Finally, please turn to page 7 of the Case Management Order, titled Attachment C, Preparing for Your Hearing. If you cannot reach an agreement on all issues in your case with all other parties in your case, the case will be scheduled for a contested hearing with a judicial officer, a magistrate or district court judge. During the contested hearing, the judicial officer will make decisions and issue orders about parenting and/or property issues. If your case is scheduled for a contested hearing, you will need to read through the Preparing for Your Hearing document on page 7 in detail. This document will prepare you for the expectations of the judicial officer at your hearing and provide you with information about the procedure of your hearing, including the evidence and exhibits you can present at your hearing. Additional resources to help you prepare for your hearing are available from the Self-Represented Litigant Coordinator and at the Self-Help Center located on the south end of the first floor of the Montrose Courthouse. Thank you for participating in the Domestic Relations Orientation today. Please remain seated and await further instructions for your initial conference.